And I'm pleased to rise to speak briefly to the Justice Legislation Amendment, Sexual Offences and Other Matters Bill. It's been interesting and really fruitful listening to this debate, and I think, you know, when the public thinks about what we do, to hear the very heartfelt and sensible comments that are being made in this chamber about this bill, I hope is, builds some faith in the Parliament itself, because this is an important bill. It will reform the way sexual violence, rape, is dealt with in Victoria by adopting an affirmative consent model, something that advocates have been calling for not just years, but I'd say probably decades. It acquits the recommendations of the Victorian Law Reform Commission, and it makes it clear that a person cannot have a reasonable belief in consent if they did not say or do anything to find out. The way someone dresses is not consent. How much that person has had to drink is not consent. How that person walks home at night is not consent. Now, we've all been, I'm sure, involved with the Me Too movement, some of us probably in a more personal way than others. And before that, we would march in the streets, and it was called, well, we had marched in the street to keep women safe at night, and that certainly started in the 1970s. We also, for many years, I was involved in a group called Slut Walk, which was again about saying that consent has to be affirmative. Consent is not suggesting, well, she seemed to like me, or, you know, gosh, she looked like she liked me, or she was dressed in certain ways. And so I think this is a proud day to be here to see this campaign come to fruition and see affirmative consent introduced into our justice legislation. I was sexually assaulted as a young person, and I'm not alone. You know, the statistics show that, you know, if there's 5 women in a room, there'll certainly be a number of us who have been assaulted. And when you look at the LGBTIQA community, those statistics become even higher, particularly for our transgender community. The statistics are alarming. I didn't report it to the police. I did speak to the person. He was an acquaintance. And, you know, and made him understand very clearly that there was no consent here, and that this was, in actual fact, sexual assault, and in fact this was rape. That didn't stop him. But, you know, after that happened, I actually went and spoke to his mates and told them what happened. And that was, I am very grateful for those fellows, those young surfer guys. They immediately acted. They immediately asked that man to leave, and they told him they never wanted to see him at the camp ever again. And we didn't. He never came back. You know, had there been an affirmative, had we had these conversations, because this was a long time ago, you know, and it's still not much better. Most women will choose, or most people who are sexually assaulted won't go and report it, because they're worried that they won't be believed. They're worried that the bar is set at a certain level to prove that they, in some ways, they have to prove that they've been sexually assaulted. And basically they do. Affirmative consent takes this back, that the perpetrator has to show that there was consent, and has to show it in explicit and clear ways. You know, the only person responsible for sexual assault is the person who did it. So I think this change, I hope will affect women today, and I hope that the outcome of this legislation will mean that more women will want to report, but more importantly, less people will be raped or sexually assaulted. That this is a part of an education campaign. This is part of, it's part of a worldwide movement. We saw New Zealand has actually prosecuted people under some affirmative consent laws and some stealthing laws that I'll mention in a moment. But we've seen other jurisdictions follow this path. We will see the ability for us to run national campaigns. This is yet another tool for us to address sexual violence in our community. So the bill also makes some important changes around stealthing and image-based sexual offences, and I'm happy to support those. As someone who's been involved in the sex worker community, there was actually, the term stealthing is actually abhorred. Sex workers prefer not to call it stealthing; they prefer to call it sexual assault. And there was, when we were discussing this years ago, there would be concerns about people saying stealthing, and I think it came into our kind of dictionary about 5 or 6 years ago. But sex workers would say that kind of diminishes the harm that action did to that person. If a sex worker is working and someone pulls off a condom without consent, that is sexual assault, and this legislation goes to that, which I'm very pleased. So despite the term, the impact is that stealthing is now seen as sexual assault. But for a sex worker, this often would mean that they could no longer work because they would have to take time off for sexual health checks to ensure that it hadn't caused any transmission of any STIs. There would also be the mental harm from this as well. So for sex workers, I think there was a sense of urgency for this to be addressed, and I think, if I remember rightly, this was also raised in the debate around sex work law reform. I'd just like to touch on the proposed amendments by the opposition, and I listened to Dr. Bark presenting those amendments, and I have some sympathy to those arguments, and I certainly think if there's a person in this room that knows about educating and speaking to young people, it would be Dr. Bark. The reason I couldn't get there was because of the consistency of the Northern Territory, the ACT, Queensland and New South Wales. So in having the same interpretations, in having the same definitions, I think we can approach this on a national level. This will, by having a standardised interpretation. Also, this provides for a body of precedent from the other jurisdictions in other areas, and I think I have enough faith in the judicial officers to navigate around the word voluntary here. And as I said, importantly, it will assist us in consistent education across the state, across the country, to assist in changing, frankly, and as Mr. Mellon put it, frankly, men's behaviour. The Greens have put up some amendments to this legislation as well, and while I agree entirely with the purposes of these amendments, and I absolutely support the advocacy from my friends at the Pride Lobby and Equality Australia, I think what those amendments do is actually highlight that we need to rework our Crimes Act, that we actually need, our whole Crimes Act needs to be updated. So there's a little bit of homework for the Attorney-General. I suspect possibly not before this election or not before the end of this term, but I think it is a very important piece of work that needs to be done, and I would compel the Attorney-General to consider putting that on the to-do list if they were to form government, or for the opposition if they are to form government after the 2020, after this year's election, that they would also consider having a whole update of the Crimes Act. So with those words, I thank you.